In a world bordering on ecological and political collapse, on political fragmentation, mass migration, the last thing we need is a pick and mix approach to international law. And yet, from Hungary to Westminster, from Denmark's selective implementation to Kemi Badenoch's new flirtation, or rather her ramped up flirtation with instructing British judges to ignore the European Convention on Human Rights, that's precisely what we're witnessing. Unilateralism, once the preserve of imperial hubris, has found new expression in populist legal nihilism. So I would argue that the rejection of international legal frameworks such as the 1951 Refugee Convention or the ECHR is not only intellectually impoverished but strategically catastrophic. And one should go back to 1949 to St James's Palace, where it all began. Britain, ravaged by war, helped lay the foundations for the Council of Europe and the ECHR. Sir Winston Churchill proclaimed, "A European Assembly forbidden to discuss human rights would indeed have been a ludicrous proposition." And yet, in 2025, we are entertaining exactly that, a Britain turning its back on its own legacy. These treaties were designed to bind civilized nations in mutual accountability, a contract, not a suggestion. To unilaterally renounce their principles is not bold sovereignty, it's moral vandalism. And of course, there are valid criticisms of the Strasbourg Court. Indeed, Article 8 has grown unwieldy, yet some judges are of uneven pedigree. But the solution to an evolving jurisprudence is reform, not rejection. You do not cure a fever by smashing the thermometer. Badenoch, Jenrick and Reform UK fail to distinguish between disagreement with a judgment and disdain for the rule of law itself. They forget that international law is not an à la carte menu. Abandoning it when inconvenient is like discarding the fire brigade because it occasionally splashes your wallpaper. We should be brutally clear. No state can solve migration alone. Denmark may build camps in Rwanda, Poland may erect fences, and the UK may invent fantastical schemes involving barges and legal contortions. But none of these are durable solutions. What is needed is a global discussion, a modern Bretton Woods for migration. We should be hosting a summit to rethink and rewrite parts of the 1951 Refugee Convention in good faith. Instead, we're sulking at the back of the classroom because we didn't get our own way. This is a strategic self-harm at a moment when international cohesion is our only hope. And the irony is this: Britain has an excellent track record at the ECHR. Over 97% of rulings against the UK have been implemented without drama. The court has helped outlaw corporal punishment, uphold religious liberty, protect domestic abuse survivors from bureaucratic cruelty. And yet the tabloid press seizes on one Albanian burglar who wins his appeal and proclaims it the death knell of national sovereignty. This is not legal reasoning. It's a political pantomime. And Badenoch, who ought to know better, is indulging it with alarming zeal. There's also the matter of political deja vu. Like much of Brexit, the argument to quit the ECHR is a promise without a plan. It panders to grievance without offering governance. We're told Brexit would mean control. It meant confusion. Now we're told that leaving the ECHR will fix immigration. It won't. Even Badenoch admits this. Doing something negative does not achieve a positive. What it will do, however, is set a precedent that international obligations can be torn up when politically inconvenient. What happens then when China cites British precedent to ignore WTO rulings, or when Russia invokes sovereign discretion to dismiss human rights claims in occupied Ukraine? None of this is to suggest that international law is beyond criticism. But the solution lies in convening allies, not alienating them. If Denmark and Italy want reform, let them join us in that task, not stomp off in a sulk because Rule 39 delayed a deportation flight. We should propose a modernised refugee convention that reflects 21st century realities. We should revise Article 8's application criteria for deportation, but we should do that as grown-up legal architects, not as demolition crews with slogans. The ECHR and the 1951 Refugee Convention are not relics, they are lifelines. Their reform must be a collective endeavour rooted in reason and reciprocity. To tear them down unilaterally is not sovereignty, it's folly. And in a time of war, climate upheaval and mass displacement, we do not need fewer rules, we need better ones, shaped in dialogue, grounded in shared values, and upheld by the courage to think internationally, not provincially. This is no time to abandon the concert of nations. This is the hour to tune into instruments and play in harmony, lest we find ourselves alone, out of tune and irrelevant.